Hi guys, it's Kathy. I hope you're doing well. Whew, whew, we made it to Wednesday night. Technically tomorrow I can move, technically. I probably won't. But I don't know if I have electricity yet because, you have to fill out. It's just, everybody makes everything so hard. To get anything, it's just so hard. Nothing is just easy. Hey, I want this. Here's my credit card. I need electricity. Here's $400. Can I have electricity? Here's where I live. That's not a real address. No, it's a real address. It really is. Someone lives there right now and you sell them electricity. Nope, that's not a real address. Yes, it is. Okay, fine. It's a real address. Okay. I need your bank account number. You need my what? I need your bank account number. For what? I have $400. Here's a credit card. Here's my debit card. Why do you need my bank account number? Just give me electricity. Okay. But you have to fill out these forms I'm going to email you. No problem. Please email them. Don't worry. We're going to email them. We need them back by the end of the day. No problem. Okay. Please email them. Please email them to me. It's almost the end of the day. Can you please email these forms? That was just electricity. It's the same thing with internet. It's the same thing with everything. It's like nobody was just like, I will give you money. You'll give me this thing. That's really it. No. It's paperwork. You guys don't make me do paperwork though. Yep. For you guys to. Shocking. For you guys to view my stream, you guys are going to start making me fill out paperwork. But I'm not giving you my bank account number because I'm too smart for that. You can have my credit card number. I don't know, guys. I don't know. We'll see. We'll see what happens tomorrow. I'm going to stop my stream tomorrow morning, go to work, and then try to figure everything out. Try to detract myself from this house. I have so much to do. I just don't want to do any of it. I don't. I'm exhausted. I don't want to move. It's one of the things I hate doing the most in this world is moving. And I gotta move. But hopefully this will be the last time. Don't tell my son that. He doesn't want to move out to a rural house. He thinks we're only there temporary to save up to get a bigger house here in the city. That's not happening. But you know what? He's an adult. So if he wants to move back into the city, I'm not stopping him. I'm just not going to pay for it. I got some court cases for you today. I did. Oh, yeah. Chocolate drumsticks are the best. Okay, but they also suck. Okay. You know how pizza is really good? You eat the slice with the cheese and the gooey. But then you eat the crust, right? And that last bite of crust makes you think, oh, I could just eat a little bit more. One slice isn't that big. I'll just have another slice. It's that last bite, that crust, makes you want another, right? Drumsticks are the same way. You eat those drumsticks and then you get to that last little point with the chocolate inside and you're like, oh man, that was really good. So I buy the drumstick minis, so they're only like this big. Oh my goodness, hello there. Welcome. It's nice to see ya. But I buy the mini ones so I can easily just say, one more ain't gonna kill me. One more ain't gonna kill me. One more ain't gonna kill me. I eat the whole thing. Look at that. We got a real professional here, and I'm yapping away like an idiot. I can't help it. Every single person in the world tried to annoy me today. It was one of those days where it's like they went out of their way to try to annoy me, and I don't know why. But it's fine. I had committed no felonies yet today, but I'm freaking this close to committing a felony. That's right. Let's watch felonies. There we go. This is probably the most interesting court case we're going to see all day. Right. I'm not going to show you this whole trial, but I did want to show you this little tiny piece of a deputy on the stand in this trial. Okay? So this is a former deputy going on the stand.
Yeah, good afternoon. And it's deputy now, right? All right. Deputy, do you swear and affirm under penalty of law that the information you provide to the court will be the truth and nothing but? Thank you. Please be seated. When you're seated and comfortable, please state your full name for the court's record and spell your last name.
Yeah, I fit. I don't. My name is Deputy Mark Smith, SMITH.
Mr. Skelton, you inquire.
Thank you, Your Honor. Good afternoon, Deputy.
Afternoon.
So, Deputy Smith, where are you currently employed?
With the Jackson County Sheriff's Office.
How long have you been with the Jackson County Sheriff's Office?
It's January.
January 26?
Yes, sir.
Okay. Any previous law enforcement experience prior to joining the Jackson County Sheriff's Office?
Almost 5 years with the Kersey Police Department, a year with Sedgwick County, and 5 years with Morrison PD, and then 5 federal.
And what law enforcement role did you have with the federal government?
Federal SWAT team.
Okay, guys, you're not going to believe this, but there are actually professional YouTubers that actually provide professional court videos where you can watch a professional do it right that are really entertaining. There's one. And you're probably all subbed there already, but if you haven't, you have to. And if you like body cams, Monica, I know you love body cams. That is where you need to go because they have the best. So, but don't expect me to be professional just because you start watching professional stuff. Because I do my best, but I'll never get there.
Okay. So would this be collectively, I want to say 18 to 17 years in law enforcement in some capacity? Is that right?
Correct. Yes.
Okay. And what was your position with the Kersey Police Department on February 15th of 2025?
Patrol officer.
On that date, a little before 9 p.m., were you dispatched to a 800 First Street, lot number 55 on the report of a disturbance?
I was, yes.
See, that was an address I just left in there.
And fair to say you received some information from dispatch prior to arriving at that scene, is that right?
I did.
And did you also go to that scene and then speak to both the reporting party, Emily Taylor, and her daughter, Amaya?
I did.
Can someone please tell me how to pronounce Leach's first name? Kquierstian? Is that K and Q separated or spread apart?
Now, without getting into really any specifics as to what each and every statement they gave you was on scene, but generally, what was the, I guess, event that was described to you that you had responded to that day?
The event that described to me was that the mother and the father had gone out to dinner, returned back to the mobile home park, and I think there was an argument, and that he had drug her out of the car and then took her cell phone and then left.
And when you say her, are you referring to Emily or Amaya?
The mother.
That'd be Emily?
Yes.
Okay. So that, and then did Emily describe what the relationship was when she said the defendant or this other person? What kind of relationship did Emily describe having with this person?
I believe they were married. I believe they said they were married.
Married or
separated?
Separated.
Sort of separated.
Okay.
At the time.
And so Emily described her ex, the defendant, pulling her out of a car, taking her cell phone, and leaving. Is that
yes?
And was the defendant on scene when you arrived on scene?
No.
Did you receive contact information for the defendant from either Amaya or Emily on scene?
Yes, I did.
Did you do anything to try to contact him?
I did. By cell phone, I contacted him, asked him to meet me at the QT gas station in Evans, so we could talk about the event.
Were you able to reach him a couple times over the phone?
Yes, I was.
Both times, did he tell you that he was going to be coming to meet you at the QT gas?
Yes.
Did he ever show up?
No.
Eventually, after you waited some time, did you clear the call and go back to the police department?
Yes, I did.
While at the police department, did you receive information from dispatch that Emily had called back into dispatch?
I did.
At that point, did you reach back out to Emily and call her?
I did, yes.
Now, are you aware that at the time you made that call to Emily, your body worn camera was not activated?
That's correct. I did not activate my body cam.
Can you describe kind of why that was?
It wasn't malicious, but I think it might have been probably doing 8 things at once. Wasn't thinking about it. Made the phone call and just didn't activate it.
Fair to say at that point you had cleared the call
I had, yes.
and you were made aware that Emily had reached out to you through dispatch.
Yes.
And so you called her over the phone. Approximately how long was this conversation?
Wasn't very long, maybe 2-3 minutes to get them my email address from them to.
So you just said on the record, sir. Sir, you just said on the record that 3 minutes is not very long. Just want you to realize it's on the record. It's part of history. Now it's official. 3 minutes is not very long.
Email me the photos of where the object was placed in the driveway, where the phone was left in the driveway after it was tracked.
Okay, so let me back up a little bit. So
Okay.
I'd asked you how long you thought the conversation was. I think you said 2 to 3 minutes. Is that right?
Yes.
Is it fair to say that although your body worn camera was not on, you did document that conversation in the report you wrote as to this incident?
Yes, I did. Yes, I did.
Okay. And do you remember what Emily told you during that conversation that you documented in your report?
I believe that I was told that while tracking the phone, they saw that the phone had returned to the mobile home park. And then when they stepped out the door, it was laying on the ground next to the car.
Were you advised by Emily that they had taken a picture of the phone?
Yes, I was.
Were you also advised that her daughter had captured a video of who she believed to be the defendant walking away from the front of the residence?
Yes, I was.
And was that all documented in your report?
Yes.
And then you described that you actually did receive the picture and the video. Is that correct?
That's correct.
And how did you receive those items of evidence?
By email.
You didn't go over to the residence to get that?
I don't recall doing that, but I believe I received them by email as I requested, I believe.
And what did you do with that email?
I took the photos and I saved them to evidence showing that the phone was now out by the car. Documented that the daughter had tracked the phone for quite a while and then saw it back in the mobile home park. And that's when they reached back out to me.
When you, I mean, you said you've been in law enforcement, I think 15 plus years. Have you
Yes.
received evidence, like electronic evidence over email before?
Yes, pictures, photos that they,
Standard thing?
yes.
Do you normally have body worn cameras on as you're opening those emails?
No.
So we are not watching this trial. We don't really care what's going on with this trial. This deputy is about to say things about the police chief, and that's what we're here for.
I normally don't. Not for that. I've never done that.
Are you interacting with the public when you open those emails?
No, I'm usually in my office.
Thank you. Those are my questions.
Thank you, Mr. Gibson.
Good afternoon.
Afternoon, sir.
So in preparing for this motions hearing, did you reread your report?
I did. I had to familiarize myself to make sure I knew what I was talking about. Yes.
Because this happened, I mean, a year and a half ago.
It is quite a while. Yes.
So a lot of your memory of what happened that day is from your report.
Yes.
And on that call, you said that Emily told you that Amaya had tracked the phone back to the mobile home park.
That's correct.
And that's what you learned specifically on the call.
Yes.
And you learned,
Oh, wait, can you say that one more time?
that's what you learned on the call specifically.
Well, it was after it already cleared and he had,
Wait,
when I left.
what? You said it was your podcast. I don't want to see, I want to see you do a podcast.
Geez.
I see I meant on the phone call.
Oh,
not
yes.
Not on the
Okay.
call for service. I understand your
Okay. Sorry.
confusion. All right. So in preparing for this motions hearing, you said you relied significantly on your report. Back in January 2026, you were fired from the Kersey Police Department.
Correct.
And in the letter firing you,
Your Honor, I'm going to object at this point. One, this is a motions hearing. So when it comes to credibility, outside incredible is a matter of law. The court's not really making a credibility finding. Two, I know the contents of this report. There's nothing under 608 that goes to acts of untruthfulness. This officer is not on the Brady list. For that reason, I can approach and we can talk about the actual specifics. I don't think we need nor should go into the specifics of the officer on the stand, but there is nothing here that would be admissible at trial, should be admissible at this hearing, particularly in the context of what decisions the court has to make today.
Well, Judge, I think it's absolutely admissible, given that that Deputy Smith was fired in part for violation of department policy as related to body-worn camera use. I think that's absolutely needs to come in.
There wasn't a policy, but okay.
It says right here. You can look at the letter if you'd like.
Well, that's fine.
Parties approach.
I don't remember a gap, and look, there's a gap, and I don't know how long it is. Son of a gun, I didn't get it. I didn't get it, guys. It's all right. It's all right. He calls the police chief names. So he got fired. Then on the stand, he called the police chief a liar, corrupt, all kinds of things. I'm going to get it, and I'm going to show it to you. I just missed. I just got off work. I just got home. And I tried to throw this together. But I am going to give you a heated battle. Here's a heated battle over discovery. Hi, Zach. Oh, great. Now Zach watches me fall down and fail, too. Zach, you're in Pennsylvania now, right? It's lovely outside.
We're just a few seconds early in Mr. Palacios-Creos' case. Deputy, who else is in the hearing room with you?
Mr. Tuck
know,
Williams,
Stephen.
he will be speaking with JP County, also scheduled for 1300. Although it's my understanding that they know
Can't
he'll
help
be
me.
late.
Ephrata.
Oh, we're set for 1:30. Oh, he was set for 1 o'clock.
Yes, ma'am.
I heard. Yeah. (26CR25) People versus Brian Palacios-Creos. Mr. Palacios-Creos appears by video from the Gunnison County Jail. Ms. Appletal appears on your behalf. Deputy District Attorney Garrett appears on behalf of the people. Mr. Garrett,
Is Sherry here?
has the discovery issue been
Sherry, are
resolved?
you here?
So I would at this point probably defer. I don't know if Ms. Aptal has been in contact with Ms. Wagner about the discovery issue. I know that I believe she reached out to the clerks and they've been talking about it. I'll be honest, I'm kind of ignorant as to what's going on with the discovery issue.
Ms. Appletal, has the discovery issue been resolved?
It has not, Your Honor. I can tell you where we are with it.
Go ahead.
Your Honor, so the issue is that there is a
Now I can't remember what they said. Gun. Is this near you too? This prison?
brief period that can in the body-worn camera footage that contains sensitive information. My concern, so the proposal by the district attorney is that the court review the body-worn camera and determine, essentially find that that is not discovery and that need not be turned over to the defense. Our position is that I would object to anything being turned over to the court that hasn't been turned over to at least the attorney of record, because that is ex parte communication. And I don't have any legal authority that's been presented for the court to accept body worn camera, evidence in the case and review it ex parte, without the defense having had the opportunity to review it. I would object to the court accepting discovery in the case, and reviewing it, because for a whole host of reasons, not the least of which, the court is going to be likely having to determine issues when it comes to things like the preliminary hearing, and determine evidentiary issues in the case. So I would object to the court pre-reviewing discovery, especially discovery that the defense has not had the opportunity to review. So I don't know of any. Oh, I see Ms. Wagner. I'll pause. May I continue? Or
Just a moment.
I can't see if
I'll let Ms. Wagner get situated.
okay.
Ms. Wagner's in the courtroom on behalf of the people. Go ahead, Ms. Appleton.
Sure. There are certainly circumstances where the court is able to review things in camera, but my concern is that in each of those circumstances, such as DHS records, there's specific law that permits the court to do that. And nothing has been presented to enable the court to proceed that way in this case. What I propose is that the court order the discovery turned over pursuant to Rule 16, but that the court issue a protective order that sensitive information can only be reviewed by counsel, and not be shared with Mr. Palacios-Creos, and not be shared with anyone
The lawyer's going to tell him everything. They all do.
Outside of this case, including in others in my office. I think that addresses the issue. I certainly, as an officer.
So before the prosecutor came in the room, she said she didn't want the court to see this information first. But as soon as the prosecutor came in the room, she said she doesn't want him to see this information. I wonder what the problem is.
Of the court, I certainly understand my obligations in abiding by a protective order, and certainly would not be using any kind of information like that for any sort of nefarious purposes. But the protective order is the way to ensure that the information isn't inappropriately shared. It is something that the court has the ability to do, and there's no reason to proceed through a different process, particularly a different process that involves presenting ex parte information to the court. My understanding is that the court would be presented with a recording that is nearly a half an hour. Again, my concerns are that if the court is reviewing evidence in the case, it presents different issues as far as the court's partiality in determining evidentiary issues in the future. And I don't know what a legal authority there is for the court to proceed in that manner versus a protective order, which the court certainly can do. Thank you.
Can we back up a few steps so that I understand sort of where we're falling under Rule 16? Ms. Apatow, have you been provided an excision as an option under Part 3 of Rule 16? Have you been provided an excised copy of the body-worn cam?
Your Honor,
Yes,
I haven't been provided with any of the body-worn cam.
She was given the option. I don't mean to interrupt, but to answer your question, that's where we started, is with her offering her to just mute it to where she could still see what was happening, just not hear the physical address of an officer that's not involved in this case, not a witness to this case, has no connection whatsoever to this case, and she declined that. So yes, she was offered to get all the body-worn cameras with just that 20-second portion muted, and she declined.
Ms.
Your Honor,
Apple?
before I was interrupted, I was going to say to the court that Ms. Wagner asked if we objected to the excision, and we did object to the excision because without knowing what is on that body-worn camera, I cannot agree that evidence should be withheld from the defense. I certainly am prepared to suggest and honor a protective order, however.
And I'll let you each respond to these questions, but again, going all the way back to whether this is an item of mandatory discovery, the content of the body-worn cam sort of dictates whether it is or isn't. Is it a statement made by an investigating officer?
And two of the officers that were at the hospital. So it was after the investigation was over. So it actually doesn't fall under the 1A immediate exception, the one within the 21 days, Rule 16. And it's not exculpatory, and it's not has anything to do with the actual case. So no, I don't actually think it falls under Rule 16. And I think that is why I wanted to present the court the entire body-worn camera to ensure that, so that someone would see that that was the truth. But I am an officer as a court have repeated many times exactly what's in that 20 seconds. And I'm not understanding, I guess, the different standards of an officer of a court to just believe them between the two discussions here. But it just seems like we are having that because we keep getting brought back to, I don't know what's on it. I've told Ms. Apatow exactly what's on it. I've told her it's 20 seconds. So I'm not understanding that discrepancy. We have had orders of protection violated in Brady cases in the Montrose County, and they're passed amongst cases. We have had pictures of a certain officer's personnel record that was taken. A subpoena was done to
Zach did that one. He did.
PD, Gunnison Police Department. Pictures of his record and finding were used in pleadings. And then records were made in the court that they didn't have access to the records and requested those again, even though actual pictures of those records were in the pleading. So the people do have concerns that a protective order, especially when you're dealing with a privacy of an officer's home that has nothing to do with the situation, we're just not willing to take that chance that it may slip through the cracks by pure innocent accident because we're prepping for trial and we just let it run and forget about that 20 seconds as we're doing so. I mean, that can innocently happen enough in a 29-minute, 33-second video while you're prepping.
I would like to respond.
I'll give you a chance to respond. I just want to clarify one thing. So the people don't believe that that portion of the body-worn cam falls under any mandatory disclosure under Rule 16.
That is correct, Your Honor.
Go ahead, Ms. Apatow.
Your Honor, there are a couple of things. First, I just want to make a record that part of the problem with proceeding the way that we are, so we haven't been provided with any of the body-worn camera, let alone a portion, even a redacted portion of it. So when the court is asking these kind of questions, the defense is denied a meaningful ability to participate because the court is asking these questions and we're essentially blindfolded with our hands tied behind our back because we don't have the information. So only the prosecution is able to answer this, which doesn't exactly place the parties on an even playing field. That's first. Second.
Yeah, but what you're asking for is too much, I think. I don't think she needs to see the inside of an officer's house. I just don't.
It sounds that as though Ms. Wagner is accusing counsel of violating a previous protective order. And if the information that she's talking about is what I understand it to be, my understanding is that what she's talking about is information that was gained through an open records request, not a request that had any sort of protective order on it. So if the prosecution is accusing the defense of violating a court's protective order, I think that information needs to be provided to the defense so that we can respond to that. I don't believe that what was represented just now is accurate. So I think an allegation that that
Honey, I think you have a guilty conscience because I don't think she was talking about you. I think she meant generally in other cases, but that's all right. Maybe she was talking about you specifically. I missed it.
defense counsel is not capable of complying with a court's protective order, I would argue is unfounded and should not be the basis of the court withholding discovery from the defense.
And Your Honor, I will clarify. One is the issue with the officer that's no longer with GPD was not a protection order. It was a request for the same information they were claiming they didn't have, but they had a picture of it in the motion that they had. And it was personal. And to me, it was being used in an abusive way. That is my personal belief. The court did not feel that way and denied that and ruled that they got the information. The information about Brady letters and Brady information on officers in the Montrose courtroom, it was raised and there were hearings about a specific violation of the protection order. And then the response from the Colorado Public Defender's Office in the Montrose courtroom is they quit signing the protection order. My concern is we are on the third set of attorneys in this courtroom in the less than a year. I don't want an officer's home address out and about to various people when we're not having a consistent flow over. I'm not saying these things are done on purpose. I'm not saying they're done maliciously or unethically, but it happens. And when you're talking about an officer's home and personal information, I have concerns that it may accidentally happen. I'm also concerned that it's a very even playing field. There's been explicit on the record statements of what is on that body cam. And if I'm being accused of not telling the truth, that's why I'm asking for an in-camera review so that the court can see that I'm telling the truth, that in that 20 seconds, it's just an officer's physical home address. So I think the accusations are far more coming from the other side that we're somehow lying about those 20 seconds that we're asking not to be relieved. And I don't know how a protection order will work when their body cams go into a system that go to Denver and then they come back to the Montrose office and get dispersed to attorneys. There's no real way that I can know or this officer can know that their information is safe because it tracks through so many different people. And it's not an officer related to the case. This is not discovery that has anything to do with this case. And so the people do look at this as falls in lines with like the Department of Health and Human Service records or something that calls for to ensure defense is getting everything absolutely guaranteed to them, rightfully theirs and should be theirs. But we protect someone's information that does not deserve this to get up.
I think Ms. Apatow's comment about body-worn cams is that, and Ms. Apatow, you can correct me if I'm wrong, but Ms. Wagner is consistent with the statements made on the record last Thursday, and that is, my understanding is there were multiple officers who had body-worn cams involved in this case, correct?
Correct.
No body-worn cams from any officer have been provided to the defense.
No, we were waiting on this, Your Honor, because there are 2 officers involved and the amount of accusations coming specifically from the public defender's office regarding discovery, we held off on body-worn cameras until we had a full ruling on it because there are 2 officers that are talking to each other. So it's going to affect their 2 body cams.
Are there any other body-worn cams related to this case?
Yes, there's quite a few.
I think that was Ms. Apatow's comment, that there are no body-worn, in response to my question, no body-worn cams have been disclosed, which is consistent with what you had indicated in open court on Thursday.
Right, because in WatchGuard, it's all going to go over at the same time. They won't parse it out into different videos, so we have to know which videos we're putting.
Ms. Apatow, to the logistical issue, if there's a protective order in place such that you are the only person who can view the body-worn cam or 2 officers, and to not disclose the address of another officer, the sensitive information included, can it be provided in a different manner than it normally is in this particular case? Those 2 videos, not every body-worn cam, but can it be provided on a thumb drive just to you as opposed to through WatchGuard evidence text at the state office, as I understand it.
Zach, thank you so much. I appreciate it. And look at that. Very first one. Anna Banana. That's so awesome. I am Jack. I wonder who that is. I am Jack. You should come in and talk to us. I want to know what your name means.
From speaking with Mr. Crane, then disseminates it to your office when you had an open protective order at that point.
Yes, Your Honor, it certainly could be provided to us on a drive. I will tell the court that I would then save it on my computer, but when something is subject to a protective order, that is documented. It is subject to a protective order, and not to be viewed by others. So, it certainly can be provided in that format. I would also say, typically, when the people that download the information in Denver, they're not necessarily like watching it all. They're downloading it into our electronic file. So I don't know that the concern would be that the discovery the discovery clerks in Denver would be having access to the information. But certainly if it was provided on a thumb drive, that would be fine as well.
Because if the court goes the protective order route, which I have concerns about based on the statement of it's okay that some people see it, they're not looking for it for that information, is not real secure in the protective order response. And so we would then ask that it be signed over to Ms. Apatow. We would ask that her investigators cannot see it, co-counsel cannot see it, that it be restricted to Ms. Apatow and only Ms. Apatow.
Ms. Wagner, anything further on the issue?
I guess I'm going to be honest. I'm really baffled why the need to have this information is, it makes me even more nervous of this big of a fight to get an officer's personal information that's not even employed by Gunnison Police Department yet. It's I don't understand, but I'm just asking the court to ensure that defense gets their lawful and required discovery, all the while protecting an officer to allow them to live in this community safely and without fear of the situation.
And Your Honor, I can respond. I mean, the issue isn't that I'm arguing just that we should be able to have the officer's address. The issue is that there's part of the discovery that's requesting to be redacted without review by the defense, and I don't know what else is on there. And I understand that the prosecution is saying that this conversation is on there, but for example, if they're at the hospital, I don't know if there's background conversation of my client making statements, if there's background conversation about, involving doctors. I don't know what's on there such that I can agree that it should be redacted. I am certainly not accusing Ms. Wagner of misrepresenting what's on there, and I have never said that. It's just that the defense is going to be reviewing the discovery with a different perspective than the prosecution is. So I'm simply asking that I be able to review that information and that it be subject to a protective order.
Okay. Anything else, Ms. Wagner?
No, Your Honor.
Oh, in the interest of time, I'm going to let the jail get the other gentleman in front of the Chaffee County Court judge. I'll issue a written order this afternoon and I'll get it to both of you. And if there's anything further, we can address it when Mr. Palacios-Creos back. For a compliance hearing and demand for a preliminary hearing. Bear with me a minute. Oh, we're set for a preliminary hearing on the 22nd. And if you all want to address it before then, because there's an issue before the preliminary hearing, I'm happy to set it for further proceedings on motion of either party.
Thank you.
Mr. Palacios-Creos, you remanded back to the custody of the Gunnison County Detention Center. Thanks,
you, Your
Debbie.
Honor.
Thank you. Have a good afternoon.
So they didn't
You as
say
well.
why, but there was a body cam of inside the cop's house, and I don't know why. Did this guy do something at a cop's house? Why was the body cam on at the cop's house? So they don't want anybody seeing this body cam. So the one lawyer was just saying generally,
You as well.
you know, we have protection orders on some of our discovery, and then the defense gets it, and then, you know, there are violations. She wasn't talking about the other lawyer, but the other lawyer did get a little ticked off about that. But I don't think you can just say, well, you don't need to see the video. I told you what the video is about. If you're going to provide evidence, then you have to, you know, you have to show the evidence. You don't have to show him. You don't have to show him what is in there, but you do have to show the other lawyer. They can't defend against it. They are blindfolded. All right, this guy does the prosecutor's job for him. Prosecutor doesn't even need to show up for this one.
How about Mr. Meehan?
I
Is Mr.
love-
Meehan on web?
Freaking love this judge. I'm just telling you, I love her. She's awesome.
Webex or?
Yes, ma'am.
Okay, great.
Yeah.
Scott Meehan, 23 CR 166.
Yes, Your Honor.
Okay, this comes on a return on summons for revocation of probation. One second. Guys, we have the window open here, and so it gets a little feedback on our microphone. So bear with us, Mr. Meehan. Okay.
Yes, ma'am.
All right. Did you hear the advisement that I gave at the beginning of for the rights that you have in regards to a complaint report a complaint report for violation of probation conditions has been filed, sir?
Yes, Your Honor.
Mr. Meehan, did you hear me?
Yes, yes, Your Honor. Can you hear me?
Okay. Yes. Did you hear me when I said, did you hear the advisement of rights that I gave at the beginning of the hearing in regards to the rights that you have whenever a
I did.
complaint report
I
for
did.
probation has been filed?
I did, Your Honor.
Okay. All right.
Yes.
Did you have any questions about those rights?
No, I did not.
Okay. All right. Let me go over in specifics excuse me, the violations that are alleged in the complaint and report in regards to your case. All right. It's alleged that
Okay.
condition number 8 was violated, sir. That deals with your participation, cooperation with, and successful completion of any referral, evaluation, assessment, or recommended program. These programs may include, but are not limited to, placement in a residential or outpatient program, counseling or treatment for drugs or alcohol, mental health, domestic violence, cognitive behavioral, offense-specific, or anger management. It says you will sign any necessary releases of information, and you understand you are responsible for the costs of treatment and services unless other arrangements, have been made through the probation officer. Specifically states that you were ordered to complete a domestic violence evaluation and recommended treatment. You were provided a referral information to Aspire Counseling, as well as other providers in the El Paso County area. As of this dated report, you had not provided proof of enrollment or completion of this requirement. That is the specific violation that's alleged in this complaint report. Questions about that, sir?
No, ma'am. No, ma'am.
Okay, all right. Mr. Roach, you have a report in regards to Mr. Meehan.
Sorry, Your Honor.
We got the wind going here, so. sorry about that.
Your Honor, this is a more unique situation for me. It is not that Mr. Meehan is not amenable to treatment or supervision. It's more or less coming down to the risk factors and instability that Mr. Meehan has, where he has not been enrolled in domestic violence treatment, and that is a problem with compliance for probation. He has reported numerous times that he does not feel he has the capacity or the supports or the means necessary to complete anything on probation. He has asked, in addition to this complaint report being filed, that he self-revoke and serve a jail sentence at the court's discretion. I can state that Mr. Meehan has been struggling substantially with his housing situation. He has been bouncing around between different hotels in the El Paso County area for several months. He does pay a mortgage on a property here in Teller County where he owned a home, but unfortunately that home burned down in the result of a house fire. And so he has been in the process of trying to rebuild with his wife and navigate that situation. However, code enforcement has also become involved, and he hasn't had heat and all of these things, where he has lived in a camper on the property, which I did go out into the field and verify as his residence. But because there wasn't any heat or those things, he and his wife did relocate temporarily to El Paso County and were staying between these different hotels. So since that's all been happening, he's really struggled to be able to maintain kind of compliance with reporting in person to probation, simply because he's not typically in Teller County anymore. He does reach out via phone and email and tries to stay in touch with probation as much as
Does anybody ever actually sit these people down and say, you know what? Probation is an alternative to jail. You can go to jail, or you can do this, and this is what you have to do, or you go to jail. Or do they tell them you really do have to follow probation or you're going to jail, or do they just assume that these people know that?
think that he can, but at this juncture, I don't know that it is realistic enough that his circumstances would change enough if given another opportunity, that he would be successful. I never say that. I always want somebody to have the ability to engage in treatment, especially with domestic violence treatment. But I would foresee, if these circumstances are unable to change in the near future, that we would be right back in front of the court with the same issues before us. So that would be my request, would be for Mr. Meehan to serve a jail sentence to conclude this matter, because I do not think he's going to be able to resolve it outside of that.
All right.
Yes, Your Honor. I would stand with the recommendations of probation. I would offer to book and close, leave the jail sentence up to the discretion of the court.
Well, Mr. Meehan, I mean, I can't very well impose a jail sentence when you're not even here. It's.
Yes, ma'am.
This is a very odd situation as well. It's so.
Yeah, but see, the thing is, Kelly, with plea deals, there's so many words. They just vomit all these words all over this guy. And I'm just wondering if anybody just says to these people straight up, this is what you have to do or you're going to jail. Point blank. Point blank.
I guess that's one of my questions is, yeah, you're not here today, one. Two, I mean, they typically look at a sliding scale for these classes, so why is it that they aren't offering him a discount for these classes?
So, Your Honor, the defendant hasn't even enrolled into his classes. He hasn't set up the evaluation to do these things, despite those referrals that were provided. And he is initially the one that has advocated out. He was signing a summons anyway for not starting in such a lengthy period of time. And in the several times we did meet and discussed it, he had shared with probation he did not believe he could do any of this based on the instability with his housing and everything else going on. And this has gone on for several months.
So he's just not doing anything.
So he's not doing
I don't have
anything,
a
and I don't
license.
believe that his circumstances will change to allow him to be able to do that.
So, but he's not even looking into seeing if he could do anything either.
Correct.
And if they're going to give him any assistance to take the classes, he's just refusing to do anything.
Correct.
So there's plenty of homeless people that do DV counseling. There's plenty of people that have life circumstances, but he's been convicted of this charge. I don't understand why he should get a pass from having to do the educational requirement that everyone else has to do. And first of all, first, why is he not here? He's under a summons to be here in court for failing to comply with any of the terms of his.
Your Honor, he was aware he was supposed to be here in person, and he emailed me about 2:13, right after 2, and then again at 2:13. We corresponded that he is appearing by WebEx because he believes that he has the coronavirus and would like to provide documentation once he has it. That is the information that he provided me right before court.
Yeah, he needs to be here. He just basically is saying he's just not going to do anything, is what I'm hearing, huh? Okay. And he hasn't done anything in more than a year. Is that my understanding, Mr. Meehan?
Technically, I guess, yes, ma'am. But I mean, I have, we've been, after our house burned down, we've been doing this demo and this rebuild, and it's become kind of a nightmare. And now we're not even allowed to go up there via the Teller County Sheriff's Department. So now I'm kind of stuck in the point where I don't have a license and I don't have a car. And just getting places is hard. I mean, I can get around El Paso County, but getting back up to Teller County has been a nightmare for me. And I have, I'm 100% disabled with the VA. I was blown up in Iraq and at Purple Heart and was wounded in Iraq, and I have limitations, but I wouldn't necessarily say that it's me refusing to do everything. It just needs to have compounded to the point where I just am not organized enough to maintain and manage what I have going on with the demo and a rebuild and my probation at the same time. It's just been a nightmare. I've tried my best to.
You're not here in court, and so
Yeah, I know.
you're going to get a.
Yes, ma'am.
Yeah, you're not here in court, and you're supposed to be, and you're not doing anything on your probation. You did not ask to appear by WebEx. You did not have consent to appear by WebEx. You're basically just telling me you're just not going to do anything. So.
No, I'm not telling you that, ma'am. No, ma'am.
Excuse me?
I said, ma'am, I'm not telling you that I'm not going to do anything. I just have, I don't know, I've had limitations to how I accomplish everything due to me not having a driver's license.
Tell me where you signed up to do domestic violence counseling, or you did your evaluation in the last year.
I went to what's the name of that? I was in the Valor program for a while at the beginning of this charge, and I don't know if I was sentenced to Valor, but I was in Valor. They deemed me incompetent, and they deemed me incompetent after I was irate because our house was burned down when I first was arrested for these charges, and I was under the impression that our house was burned down by somebody who was trying to kill us in our neighborhood, and I pretty much have the evidence to prove that. But anyways,
I'm
it's
not talking about your house.
story.
I'm talking about the
I'm saying-
domestic violence evaluation, sir. Where did you have it done?
Right. I haven't had it done.
Right.
That
And you've had more than
I
a
can't
year
remember
to
the name
get
of the
that done.
program. I can't remember the name of the program that I was in before when I was in Valor. That is a program that they use where everyone goes and gets their medications from, and I not to look through my paper to find the name of it, but that was where I was supposed to go get my evaluation done, and it was never scheduled.
So you
And
never
like,
scheduled it.
No, I never scheduled it. I called and I talked to the doctor in there, and there's requirements of me going to that program that I had to present like requirements, and I was in the middle of getting those requirements, and and ended up not being done. And that's on me. That's my fault. And that was fairly recent. It was a few months back.
Are you going to be proceeding in regards to this revocation, sir?
Am I going proceeding? Man, I didn't hear what you said.
Are you going to be hiring an attorney? Are you applying for the public defender to represent you?
I'd like to apply for a public defender or hire an attorney. It depends on if I qualify.
Well, which are you going to do?
Try to qualify for one.
All right. Are you getting an application? What are you doing?
Yes, I will. I will get an application and I will fill it out and I will turn it in.
All right. We're going to set you for a hearing, contested hearing. That date will be
July 8th at 3 o'clock.
July 8th at 3 o'clock. You will be here in person, sir.
Okay.
Not okay. You will be.
Yes, ma'am. I will be there.
It's a Monday.
Oh, sorry, Monday.
Like me here in person,
No, yes.
Your Honor, I would need
Yeah.
a Monday. Thank you.
Sorry, different date. Hold on.
Okay.
29th at 3.
June 29th at 3 o'clock.
I
Is
can
that
accept that,
better?
Your Honor, yes.
So that will be the date, sir. June 29th at 3 o'clock.
Yes, ma'am.
All right, so you need to get on applying for the public defender immediately, all right?
Yes, ma'am, I will.
All right, we will see you here on June 29th at 3 o'clock.
Okay. Thank you very much.
Thank you.
I believe I did file a motion for a PR bond so that Ms. Winkle could be transported to the Foundry. She's been accepted. Her acceptance letter was also filed, and then I reached out to Mr. Williams, who let me know that that motion can be considered unopposed, and I emailed the division to that effect.
Okay, we'll get it out. I'll grant them electronically.
Thanks, Judge.
Why don't we do during arraignment week? Let's do July 14th at 10.
And can that be over WebEx, assuming
She's in treatment.
Thank you, Judge.
Thank you.
Thanks.
Anybody else?
No, either Mr. Governor or Mr. Richards already available.
Okay. Mr. Cavender?
It's an old man. I appreciate it.
Mr. Cavender is here with Ms. Jones.
Arthritis in my knees. Okay. I appreciate that.
Of course.
And I'm legally deaf, but he knows that.
Ms. Jones?
Okay,
Yes. Do we have the, like, hearing assistance?
that's better. Thank you. They say light surgery, I could hear again, but better have money.
I don't know if we can
Yeah,
put it on.
that's my good ear. Thank you kindly. I appreciate it. Nice to be able to hear. Unless it's mama, of course. It's over here. Sorry.
It's turned on. Is it on? Can you hear? Okay.
Okay, I appreciate it.
Okay. Mr. Cavender has a couple cases before the court today. We're here to ask first that he be granted a PR bond. He has assured me if he gets out today, he will not drink. He will come to his court dates. He's eager to get these cases taken. Additionally, it is against his due process and Eighth Amendment rights to be held simply because he cannot pay when a similarly situated individual that could pay would be able to get out today.
Okay, thank you. Mr. Craig?
Judge, I apologize. I don't recall there being a notice of this, so I'm just pulling up the notes. I would oppose a change in the bond beyond the sheer number of cases. They're all VPOs, I believe, or trespass. In reading through the cases, oh my goodness gracious, I'm trying to find. There's defecating and drinking near the Alpine Bank and I forget what the restaurant is there, Applebee's near Horizon Drive. The tone of these people, because there's protection orders keeping them from those properties, is practically begging because of the behavior and the issues he presents for those businesses that are trying to work. What I could tell the court is I have also conveyed an offer, and I just cannot find the email for that, but it's been out for more than a bit to try to get these cases handled.
Okay. Bonds will remain the same. The protection order arises from a Garfield County case prohibiting him from drinking. All the other ones are, I think he's basically been trespassed from just about every business, from Safeway to Starbucks to the dental office to Alpine Bank and Applebee's and everything else. So the bonds will remain the same, but what we'll do is if there's an offer, we can bring it back on Friday and maybe have a resolution. If there's an offer that's conveyed.
We did have an offer, however, there are new cases and we would like time to negotiate to include that case as well.
Okay, just give the number to Mr. Craig and then email it to my division so we can get it on the docket for Friday.
Okay.
So see you in a few days, Mr. Cavender. Dennis Richens, 26M 1312. You're good to go, Mr. Cavender.
You're going back with the deputy.
Can I come back to court again?
Yep.
Friday.
Oh.
Represented to be Mr. Beery is that you're pleading guilty to all the charges and all the cases subject to open sentencing. That would also include all the counts and the probation violation complaints and the two cases, one that you're on probation for unauthorized use of a motor vehicle, Class 1 misdemeanor, and unlawful possession of a controlled substance, a Class 1 drug misdemeanor. Those are the two cases that are holding you that you're on probation. The other ones are traffic and license violations. Those charges range from no proof of insurance, driving under restraint, having fictitious plates, and possession of drug paraphernalia. Another charge of no insurance, driving after revocation prohibited as a habitual traffic offender, having fictitious plates, possession of drug paraphernalia, no insurance, driving after revocation prohibited as a habitual traffic offender, and fictitious plates. And the final one is no proof of insurance and driving under restraint. I'd asked Mr. Craig, and he verified that you do have a prior no proof of insurance conviction within the last 5 years, which means for every one of the no proof of insurance counts, it's a minimum mandatory $1,000 fine that I can't suspend. The other charges carry with it. A habitual traffic offender can be up to a year in jail. Fictitious plates can be up to 90 days in jail. Possession of drug paraphernalia is a $100 fine. The counts in the complaints are that you failed to attend a scheduled office appointment and tested positive for a controlled substance. That's in 25 CR 729. In 25 M 1168, the counts there are that you tested positive for controlled substances, failed to submit to drug testing, failed to complete substance abuse treatment, failed to attend scheduled office appointments on 6 different occasions, and failed to secure employment as directed by your probation officer. By admitting those counts in the probation violation complaints, you'd be subject to open sentencing, which can be up to 364 days in jail. Any questions about your rights for me or Mr. Veery?
No, sir.
You understand on each of these forms, when you plead guilty, you waive or give up those rights,
Yes, sir.
which for you includes your right to plead not guilty, which you did in one case, setting it for trial and making the district attorney prove beyond a reasonable doubt all the elements of those particular charges arising out of operating a motor vehicle. Do you understand that?
Yes, sir.
The other 2 cases, the probation cases, by admitting all of those counts, you're waiving your right to a hearing, making the DA prove to me by a preponderance of the evidence, meaning more likely than not, you violated your probation by testing positive for controlled substances, not attending scheduled office appointments, not completing substance abuse treatment, not gaining employment. Anybody forcing you to waive your right to a hearing in each of those cases?
No, sir.
What pleas then do you enter to the charges of no insurance, driving under restraint, having fictitious plates, possession of drug paraphernalia, operating a motor vehicle as a habitual traffic offender, and counts 1 through 6 in the probation violation complaint 25 M 1166, and counts 1 through 3 in 25 CR 729. Guilty or not guilty?
Guilty.
Is there a factual basis for the pleas?
No, we waive, Your Honor.
I'll find that, Mr. Bond, you made a knowing voluntary waiver of your rights as well as entry of the guilty pleas. The probation violation complaints are sustained. As to sentencing, Mr. Veery?
Your Honor, so I spoke to Mr. Bond quite a bit about how we're going to resolve these cases. Mr. Bond really, I think as the court can tell just by the nature of the proceedings that we're at here today, Mr. Bond really just wants to get this done and over with. Prior to today, I mean, really up until just a few moments ago, the offer was just to plead open on everything, on all of these cases. And so Mr. Bond was sort of presented with the option of either, do I set all of these for trial and hearing, or do I really just come before the court and sort of fall on my sword and say, I screwed up and I just want to move on. And Mr. Bond has chosen the latter option there. One of the things that's really motivating him is that he knows somebody who is willing to hire him as part of their business recycling tires. But they refuse to do so unless Mr. Bond can demonstrate that he's sober and staying sober. So when I spoke to Mr. Bond about this, I was kind of just making small talk with him, just saying, oh, so like shredding up tires for, say, like a kid's playground or something like that. And one of the things that he pointed out to me was that actually, no, according to regulations, you can't do that. There's all these chemicals that leach into the rubber of these tires. And so, and then he started going into more about what the applications of the shredded rubber is that aren't children's playgrounds. And so what that told me is that, this is something that Mr. Bond is serious about, that he has discussed and done research on. And it's a real, venture that he's looking forward to partaking in, and not just, some sort of half thought out idea that he just threw out there of, oh, I've got a business opportunity. I really think that, based on the conversations I've had with him, that he's extremely serious about all of this. He told me that he would like to ask the court for 90 days of jail on all of this. The reason for that is that he thinks that that's enough to prove one, himself, to his business partner, and then also the court and the people here, that he's taking this seriously. He thinks that a 90-day clean break in jail is enough for him to get clean, to prove that he's clean, and give him a good starting point to stay clean. I'm sure the court's aware that, these are all, a majority of these cases are traffic cases. And I spoke to Mr. Bond about that, why are you driving under these, you just keep getting in trouble because you keep driving and you can't stop. And he let me know that, part of it is, he might have like a side gig where he's the only way that he's going to be able to eat is if he goes off to this job. And, I think in one instance, he was helping to go pick someone up who was in distress, and he ends up getting behind the wheel when he knows that he shouldn't. And then that ends up with him back in court, and then he's, might lose a gig that he had because he's in jail for a few weeks, and then he gets out and he's stuck in this cycle that he can't break out of, and he thinks that a sentence around 90 days, which is what he's asking for, would really do a lot to help him sort of break free of that cycle, put all of these cases behind him, put the probation behind him, and he can just be out and be able to work on himself, work with this business partner, and eventually work to getting a valid license and getting behind the wheel of a car legally so that he can just move on with his life. And so we're just asking the court, I know that there's going to be some mandatory fines here, and I ask that the court keep those to the minimum in all applicable circumstances. But otherwise, we would ask the court to do 90 days of jail in all of these cases, or at least in all of the cases where 90 days of jail is a legal sentence, and run those concurrent. And I will also point out that in 26M 1458, Mr. Bond does not have any credit so far in that case. Well, I'm sorry, he actually should have credit from, I believe, at least May 22nd. So that's 18 days of credit in the least amount of incarceration, or in the case with the least amount of incarceration, just to give the court an idea of which case would be holding him the longest. And so we would just ask for 90 days of jail to finish out all of these cases so that Mr. Bond can move on and act on these plans that he has.
Okay. Mr. Greg.
Judge, in speaking to the probation cases first, the 25 CR 729, the allegations were that he stole a car from a Motel 8, and then he pled to the unauthorized use on that case. And then in the other probation case that he's on, it's the DM1. He had meth on him when he was contacted by law enforcement for the unauthorized use case as well. In reading that report, the officer writes, I think in exasperation, that case was his 8th time that he'd been charged with possession of methamphetamine. And over the course of years, and I think methamphetamine is a big issue. In the DM1, the other probation case, the biggest concern there is he was driving without a license, without insurance. He ran an intersection and hit a lady, and then continued driving. He also took out a fence, and we pled him to the DM1 because, quite frankly, when you look at his driving history, at that point in time, pleading him to a traffic case is the same as doing nothing. He hasn't had a driver's license since 2001. His criminal history includes a DUI in 87, 2 of them in 87, another in 1990, another 2 of them in 2005, another in 2008, 2013. Those are just the DUIs. The more recent ones is a failure to obey a traffic control device in 2025, and then an unregistered vehicle in 2025, driving under restraint in 2025, a DARP in 2025, a DUR in driving 2025, another DARP in 2025, and then the no proof of insurance in 2025. The other thing that was pretty notable for the people is when I looked throughout his cases back to, I think, 2001, the only time he's ever paid any fines or fees is when he had a cash bond, and those bonds went to those fines and fees. This includes restitution and I think around $20,000 in one of the cases that's just never been paid. I think I can note in the case of the DM1, I doubt there's been anything paid in that one. I hadn't looked. And then as probation, I'm sure can speak to, he just did nothing while on probation. I think anything less than a year on those two cases alone, given the community safety, the drug issues, is what's required at this point. And then when we look in his driving cases, the biggest concern beyond the ones that are just present, is he routinely takes other people's driver's license license plates. In the 26T965, that's the only charge, is the fictitious plates. He's driving the same GMC he's always driving, but he has a Kia Sorento license plate on there. He said he just found it and put it on his car. On the 26M 1194, he has a trailer license plate on it that he said he just kind of put on there to get through town on that date. On the 26M 1072, he has somebody else's license plate on there. And he said that he borrowed the license plate from a friend. In other cases, the license plates have been confirmed to be stolen. In other cases, what he does is, in the registration, he'll put a magic marker to change the year or to actually change the license plates numbers. I think this is in an effort to defraud people if they try to run his license plate. In the case of accidents, he's never had insurance on, I think, almost every case he's had. The only reason we don't have driving in the 2016-956 is because law enforcement contacted him before he started driving and they confiscated the license plate and told him not to drive. I think 90 days in all of those cases is appropriate. I think consecutive, because they're all separate incidences, and we're just at a point where what is there to be done? There's so many accidents that have occurred. In these cases, not necessarily so, but we're just at a point where there's nothing this court can do to ensure that he doesn't drive, that he drives properly, or at least with insurance, or does anything that would ensure community safety.
Ms. Cross, anything from probation?
Just that I would agree with that jail is more appropriate than probation because he did nothing while on probation.
Okay, thank you. Mr. Bond, anything you want to let me know?
I tried getting into rehab and stuff just recently, and I don't know, that's not working, I guess. I don't know. Can't figure out how to do it or get there, but
ask somebody, Mr. Bond.
Well, that's what I've been doing.
Oh, ask people in the jail.
Yeah, that's what I've been doing is to find out, and that's how I'm finding out what I am.
Okay.
But, I mean, in the meantime, no, I don't have.
Okay. Probation cases, a court will revoke and terminate your probation, sentence you to 6 months of direct jail. I think he's got 17 days since the last warrant was issued on the 22nd of May of credit towards those. The probation cases will run concurrent. In 26 M1194, there'll be a $1,000 fine for the no proof of insurance, a $100 fine for the fictitious plates, suspending a $100 fine for driving under restraint, possession of drug paraphernalia, 25T2198, $1,000 fine for no proof of insurance, 6 months of direct jail for driving after revocation prohibited as a habitual traffic offender to run concurrent with the probation cases. 2016-956 will be a $200 fine for fictitious plates. 26M1072, $1,000 fine for no proof of insurance, 6 months of direct jail for driving after revocation prohibited as a habitual traffic offender. Driving under restraint suspended, $100 fine. Fictitious plates is $200 fine. In all the cases with driving after revocation prohibited, it's a $3,000 fine that's suspended based upon the jail sentence. 25T2544, $1,000 fine for no proof of insurance, $100 suspended on the driving under restraint. Anything else, Mr. Berry?
I'm sorry, Your Honor, did the court call 26M1458? That's the newest case. We did submit Rule 11s with that case number referenced on there. I was hoping that we could take care of that as part of the same. That's my mistake for not inquiring with the court at the beginning.
Do you have that case?
Yep.
Okay. $1,000 fine for no proof of insurance, $100 fine suspended for driving under restraint, $200 fines for each of the registration, fictitious plates not suspended, tail lamp violations, a $50 fine that I'm suspending, as well as possession of drug paraphernalia, $50 fine suspended. Anything else, Mr. Craig?
I don't think so, Judge.
Thanks for coming over, Ms. Cross. Good luck, Mr. Bond.
Thanks, sir.
Sorry.
3,000 suspended. 6 months of jail. Yeah, the 2 cases that have DARP.
Yeah, because my probation.
Yes. Yeah.
We'll talk about it.
Ms. Apatow, can you hear me okay?
I can, Your Honor.
Mr. Bobbitt, can you hear me as well?
Yes, Your Honor.
These are cases 26 CR 28 and 26 CR 29. People versus Brandon Bobbitt. Mr. Bobbitt appears by video from the Gunnison County Jail. Ms. Apatow appears on his behalf by video from the Montrose Public Defender's Office, and Deputy District Attorney Garrett appears on behalf of the people. Ms. Apatow, do you waive formal advisement with respect to both matters?
I do, Your Honor.
Mr. Bobbitt, you're subject to a mandatory protection order in these cases. I'm going to issue one with respect to each case. Each prohibits you from harassing, molesting, intimidating, tampering with, or retaliating against any witness to or victims of the acts charged. I'm going to start with the 26. Bear with me just a moment. CR 28 case in which Ms. Waite is listed as the protected party. Ms. Apatow, does Mr. Bobbitt have any objection to the requested conditions in the people's request for protection order terms?
Your Honor, we would just request that there be a provision for a civil assist. He does have items that are at a shared residence, so we would ask that he be able to seek a civil assist to retrieve them.
Any objection to a one-time civil assist to retrieve personal belongings with law enforcement, Mr. Garrett?
No, Your Honor.
So in that case, Mr. Bobbitt, in order to reasonably ensure the safety of Ms. Waite, she'll be listed as the protected party. You're to vacate her home and any location where she is or is likely to be found. You're not to directly or indirectly communicate with her. In other words, no contact. The only exceptions would be a one-time civil assist with law enforcement to retrieve personal belongings. In this case, you're going to need to reach out to the Gunnison Sheriff's Office to set up that civil assist. You would be in violation of the protection order if you come into contact with Ms. Waite, even to retrieve personal belongings without a law enforcement officer present. Just a moment, Mr. Bobbitt, and for the record, Ms. Waite just joined in the virtual courtroom. Ms. Waite, I'm talking about the terms and conditions of the protection order. In addition, you're not to possess, purchase, or control a firearm, any weapon, or any ammunition, and to relinquish for the duration of the protection order any firearm or ammunition that you have in your possession within 24 hours of your release from the Gunnison jail, and to file proof of relinquishment with the court clerk's office within 7 days. You'll get both the protection order in writing and the firearm and ammunition relinquishment documents, but do you understand the terms of the protection order in that case, Mr. Bobbitt?
Yes.
In 26 CR 29, does Mr. Bobbitt have any objection to the terms and conditions of the protection order as filed by the people?
Your Honor, in 26 CR 29, reviewing the information that is contained in the affidavit, respectfully, we do not believe that there is probable cause for count 1 felony menacing. while there are allegations that Mr. Bobbitt was in possession of a firearm and that there were other people that were in the vicinity, there is no information that suggests that he was threatening or using the firearm to threaten any individuals involved, or that he attempted to place anyone in fear. I would just note the distinction between people being in fear, seeing him having a firearm, and an intent to place people in fear. And I would argue that the latter is missing here, and that's what the elements of 183206 require. So, Your Honor, we would argue that the non-mandatory terms of the protection order should not be imposed because there is not probable cause for felony menacing. And without felony menacing, none of the other remaining charges would be VRA and would justify non-mandatory conditions. So we do object to the non-mandatory conditions in this case.
When you're ready, Mr. Garrett, any response?
I understand the defense's argument. I mean, what's being alleged is that he was intoxicated while driving. One of the workers at the camp told him to park the vehicle. He got out of the vehicle, got back in the vehicle, drove the vehicle, and then parked next to a shed, at which point he brandished a firearm. They felt it was unsafe due to the amount of people at the campground. They then called 911, understanding that she's arguing the intent portion of felony menacing. I mean, I'll leave it to the court's discretion to find if they find probable cause or not for the felony menacing. I mean, I think the reality is this is going to be, I know, understanding that it's being charged as two cases. I think it's the same criminal conduct episode. Once we charge, I have a feeling that the DUI case will be dismissed and will all be charged under the 26 CR 29 case or 28 case. But I'll leave it to the court's discretion as far as probable cause, understanding that there's probably not an incredibly strong argument at this stage in the investigation for the intent portion of felony menacing.
Thank you. Ms. Apatow, anything further?
No, I guess I would just say, Your Honor, that when it talks about like brandishing a firearm, again, it's not talking about brandishing a firearm towards any person or intentionally in the view of any person. And I think a difference between just the other two charges, the reckless endangerment charge and the prohibited use of a weapon charge, is the intent to place or attempting to place specific individuals in fear of bodily injury. And we don't have that here.
And I will just note that I reread the affidavit because I read brandishing and assumed that there was some physical action. I think maybe the officer chose that word when displaying would have been a better word, but I understand that what was being alleged in the probable cause affidavit, and based on the four corners of the affidavit, there's not probable cause with respect to felony menacing. I though wonder if we ought not to with that, I suppose I sort of put the cart before the horse. Mr. Garrett, are the people asking back in Ms. Waite's case with respect to the protection order for no alcohol or legal controlled substances provision or no?
We are.
And that just wasn't checked, and I guess I should have asked that before. Does Ms. Apatow, that's really the only difference other than the difference in totality between the two motions for 18-1001 protection order terms and conditions. Does Mr. Bobbitt have any objection to abstaining from the use of alcohol and illegal controlled substances as a condition of the protection order Ms. Waite's, the case in which Ms. Waite is the named victim?
Are you asking me directly? I'm sorry.
No, I'm asking your attorney.
No, Mr. Bobbitt, let me, I'm just taking a look. Your Honor,
I didn't see yet any Bobbitt jokes. Anybody? Did anybody rise to the occasion? Anybody? I'm not going to scroll up and look at all of them, but my goodness, I just want to know, yes or no?
I realize it's a little bit difficult of a situation for the court. But I guess the concern is that I don't see any allegations of alcohol use in that case. It appears from the timeline that the events in 26 CR 28 took place earlier in the day, and that perhaps there was alcohol consumption in the interim.
Drunken Smurf, we are not worthy of you. We are not.
So based on my review of the probable cause affidavit in 26 CR 29, Detective Summer indicates that the incident described above is alleged to have occurred on June 6, 2026, just minutes prior to Mr. Roberts' arrest in a separate call for service. I don't know that he has the date correct, but I think the time frame is, as I read the two affidavits, as is articulated by Detective Summer in that last narrative concerning the relationship between the two cases. Given the allegations and the probable cause affidavit in the case in which Ms. Waite is listed as the protected party and the severity of the allegations, I am going to order that as a condition of probation, or excuse me, a condition of the protection order that Mr. Bobbitt abstain from the use of alcohol or legal controlled substances. In the 26 CR 29 case, Ms. Newman will be listed as the protected party, and Mr. Bobbitt's not to harass, molest, intimidate, tamper with, or retaliate against any witness to or victims of the acts charged. Mr. Bobbitt, the protection orders will stay in place until you successfully complete any sentence that's imposed, unless they're modified by court order. If there's probable cause to believe that you violated the terms and conditions of the protection order, you could be prosecuted for contempt of court or charged with a new crime violation of a protection order, which is punishable by jail or fine, or both jail and fine.
Judge, if he does it, you're not going to find him in contempt. We all know this. We see this every single day, and they never get charged with contempt. So you're not allowed to sit there and lie. I'm pretty sure lying as a judge is illegal.
Which is a mandatory arrest. Do you understand all of that?
Of course.
Yes, I do.
Ms. Waite,
Can I just ask a clarifying question, please?
Because if they gave him a shirt, he would strangle himself with it, or someone else. So they're not allowed to have, when they have the turtle suit on, they're not allowed to have any other clothing. They're just a danger to themselves and others.
In 26 CR 28, is the court finding, is the court imposing the no alcohol provision in that case or in the 29 case?
28.
Okay. And then in the 29 case, did the court find no probable cause with respect to the felony menacing count?
Correct.
Okay. Then we would just ask the court not to impose any non-mandatory conditions in 29.
This one, did the victim speak twice yet or just once? I'm going to wait.
And none are.
Okay. I just wanted to clarify that. I think I misheard the court. Thank you.
Ms. Waite, you're entitled to be heard on the amount and conditions of bond in 26 CR 28. You also don't have to address me, but if you'd like to, is there anything you want to share with me about the amount or condition of Mr. Bobbitt's bond in that case?
I didn't hear what the conditions are for him.
There are not conditions of bond set yet.
Okay. I would like no bond, please.
Mr. Garrett, the people's position on bond, and if you want to combine arguments.
Clear as day. I would like no bond, please.
With respect to both, that's fine with me.
So, Your Honor, what's being alleged in the probable cause affidavit is incredibly serious. I do have sincere concerns for the victim in this case. Additionally, I do have concerns for the community with what's being alleged as far as driving under the influence into a camping area or the Mesa campgrounds where there were numerous people, at which point a gun was brandished. Officers initially went to the vehicle. He would not comply. They were able to talk him out of the vehicle. I know that there were several statements made once he was out of the vehicle. I think based off the number of people who are around, it is concerning as far as community safety. It's incredibly concerning as far as what's being alleged to have occurred in the victim in this case. I do believe that a high cash bond would be appropriate in 26 CR 28. I would leave it to the court's discretion in 26 CR 29, noting that this is a second DUI or is being prosecuted as a second DUI. He has a DUI conviction out of Hall County, Georgia in 2011. So people's request would just be that the court impose a high cash bond in 26 CR 28 out of fear for community safety and out of fear for the victim.
Thank you. Ms. Apatow, defendant's position on bond.
You know, we are asking the court to impose a personal recognizance bond in this case. I would note that there's not any...
Hi, Beth. Thank you for the sunshine. I appreciate it.
There doesn't appear to be any concern about court appearance. When it comes to concern about community safety or safety of the alleged victim, I would note, Your Honor, that what will likely be happening given the no contact order is that Mr. Bobbitt likely will need to return to his property in Fort Garland, which is a couple of hours away. That doesn't present any issue in terms of court appearance because he does have a vehicle and a license. He has been employed at the Mesa campground. It's not clear whether he would be able to continue that employment, however, if given the protection order. But again, he does own property in Fort Garland where he would be able to reside. And before coming to Gunnison for employment, he had resided there for the last 5 to 6 years. There's nothing to indicate that he wouldn't be able to abide by the court order or the protection order. And frankly, having some distance between himself and the alleged victim, I think addresses some of the concerns that the district attorney presented. Your Honor, we did note he was willing to abide by the protection order just with the assistance of a civil assist. And I'm seeing nothing to indicate that he presents any community safety risk with these conditions or that he is any sort of flight risk. Thank you.
Thank you. Ms. Waite, anything that you want to add now that you've heard what the attorneys have to say? If not, it's okay. You can just say no thanks.
I agree. I work here, in Gunnison until October, and we can absolutely keep our distance from each other. I'm not in fear of my life or anything like that. So,
that's what happened. That's what just happened. The victim was like, no bond. Oh, I'm not in fear of my life. I'm joking. Judge, I was just joshing you a little bit. I thought it was a joke. I thought it was funny. Never mind. He's fine.
I agree with what the public defender says.
So, Mr. Bobbitt, I'm required to set your bond to reasonably ensure that you appear for court and to protect.
I'm sick of victims. Now, even victims are trying to get on my nerves today. Everyone is trying to get on my nerves today.
The safety of the community. And the named victim in 26 CR 28. I don't have any reason to believe that you won't show up for court to resolve these matters. But I do have significant concerns both for Ms. Waite and for the community writ large, given the allegations in both of the probable cause affidavits. In 26 CR 28, I don't find that a personal recognizance bond is appropriate given the allegations in the case. Bond will be set at $5,000 cash or surety. Conditions of bond will...
The judge listened to the first thing she said.
include the following. You're to acknowledge the protection order before you're released from custody. You are to keep the court clerk's office notified in writing if you have any changes in your contact information. You are not to commit a felony offense while at liberty on bond. You are to contact a licensed mental health professional within 24 hours of your release from custody, complete a mental health evaluation, and comply with any recommended treatment. And in 26 CR 29, bond will be set at $1,500 cash or surety, consistent with similarly situated defendants, and given the allegations in the case. I have concerns about community safety. I don't find that a personal recognizance bond is appropriate. Mr. Bobbitt is being prosecuted for driving under the influence of the second offense in that case. As a condition of bond, you will need to acknowledge the existence of the mandatory protection order, keep the court clerk's office notified in writing of any changes in your contact information, not commit a felony offense while at liberty on bond, abstain from the use of all alcohol.
Judge, we don't understand why you said it once and now you said it again. Don't commit a felony offense while you're on bond. I'm pretty sure you could have left out the while you're on bond portion of that, right? I mean,
and illegal controlled substances, and have your sobriety monitored within 24 hours of your release from custody by twice weekly random urinalysis or 80-hour testing. I will get orders concerning the conditions of bond in both of the cases to you by way of the jail, along with the protection orders. If you don't show up for court or you don't comply with the conditions of bond, Mr. Bobbitt judgment could enter against you and in favor of the state of Colorado for the amounts of the monetary amounts of bond in each case. Ms. Appleton, does Mr. Bobbitt want continued representation by your office?
I believe so, Your Honor.
Come back for return on filing of formal charges. And in 26 CR 28, firearm or ammunition relinquishment compliance hearing on June 18th at 9 o'clock, the next regularly scheduled public defender docket day. Mr. Bobbitt, if you post bond, you need to make certain that you fill out an application for court-appointed counsel and remain in contact with the public defender's office between now and then. Anything further from the people in these matters for today?
no, nothing
Anything further from the...
They're done. All right, if you're here for court videos, they're over for today. I'll be back in 6 hours. Josh, I have a question. A 2004 Chevy Malibu something. It's not like there's no fob. There's a key, but no fob. Like you have to turn the key to unlock the door. Does that make sense? But you can control the locks on the door. What I'm asking is, how hard is it to get a second key made for that? Can you take it to one of those machines or not? Or do you need more information? Yes, I use Josh. I use him. Guys, I'm going to be off for 4 days. I'm going to be off for 4 days. But Discord is open 24/7. So feel free to get in Discord and talk to each other. Tell each other which channels you're watching. Look, I love when you guys talk about other channels. I just think the more we support court channels, the better court channels will do overall. So we would all lift each other up. So, I'm gonna text you, all right? I'm gonna send you some pictures. So talk to each other in Discord. Maybe something else. Maybe in the next 4 days. Think about a food dish that you never ever tried cooking before. And then when I come back Tuesday morning or Thursday morning or whatever morning 4 days from now is, I don't freaking remember, it doesn't matter. We can all talk about like, oh, I want to try this food. But go to Discord and talk to each other. Yeah, nothing negative about other channels. That's a big no-no. I don't care how jerky they are. We don't want to bash any other channels, period. That's not helpful. That only hurts us. Okay. Thank you so much for coming out. I'll see you guys in a couple hours. Get some sleep. I'll have some more court in a couple hours, and that'll be the last one for 4 days. All right? And then hopefully you all remember me 4 days from now. You don't forget about me, which is going to happen with some of you, and I get that. I'll miss you, everybody who I lose in the next 4 days. I'll miss you. So next year, come back, and we'll all say hi to you. But I'll see some of you in a couple hours. Thank you for coming out. I appreciate it. Have a great night, guys. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a